All right, I will call this meeting of the Senate Judiciary Committee to order. Will the Secretary please call the roll?
Senator Flores.
Present.
Senator Ornshaw.
Here.
Senator Lang. Senator Wynn. Senator Hansen. Senator Krasner. Senator Ellison. Chair Scheibel.
Here, please mark Senator Wynn present when she arrives. Welcome everybody to Senate Judiciary. We have a couple bills on for hearing this afternoon. We will go ahead and get started with the first bill on the agenda. It's my intention to take them in order this afternoon. So I will open up the bill hearing on SB 67 and invite our presenters up to the front. I think we have presenters in both Las Vegas and Carson City on this bill.
Thank you, Chair Scheibel. Good afternoon, members of Senate Judiciary Committee. Teresa Benitez-Thompson, Chief of Staff to Attorney General Ford, here to introduce you to our General Counsel, Leslie Nino-Pirro, who's going to present SB 67. We do have an amendment on the bill. We have 20 paper copies present here in Carson City, and I believe it is already attached on Nellis under exhibits, and we'll be speaking to that as well. Otherwise, I'll hand it over to our GC.
Good afternoon. For the record, Leslie Nino-Pirro, Leslie-Nino-Pirro, General Counsel for the Nevada Attorney General's Office. Thank you, Chair Scheibel and committee members, for allowing me to present Senate Bill 67 today. SB 67 would make a few helpful changes to the way the state and political subdivisions provide defense and indemnification to state actors. Nevada law defines an official attorney as the Attorney General or the chief legal officers or other authorized legal representatives of political subdivisions, such as county district attorneys or a city attorney. And so I don't get confused, I'll use the term Attorney General in my testimony. I'll also refer to state employees, although the Attorney General also defends officers, judges, and certain contractors. So I'll dive right in. Section 1 addresses requests for defense under NRS 41.0339. In lawsuits where the state of Nevada or state employees are sued, service of process is governed by state law and state and federal rules of civil procedure. Nevada law requires service on both the employee sued and the Attorney General. This dual service is very important because it alerts the Attorney General to a new lawsuit, which can allow the Attorney General to protect the state's interests and limit the state's potential liability. NRS 41.0339 identifies the circumstances under which the Attorney General provides defense or employs outside counsel. The statute gives an employee who's been sued 15 days to request a defense, but it does not specify which part of the dual service starts the clock, when the Attorney General is served or when the employee is served. Section 1 provides a solution to this problem, specifying that the clock starts when the employee is served. This change is needed because we've witnessed some former state employees try to have their cake and eat it too. They evade personal service, but expect the state to defend them. Moving to Section 2, this section addresses employees retaining their own counsel. NRS 41.03455 allows an employee to retain their own counsel to defend a lawsuit. As the statute is currently written, an employee cannot retain counsel until after they submit a defense request. However, this presents a problem in situations where a state employee retains private counsel from the very beginning of the case. This change in the law would allow an employee to hire private counsel whenever they choose, without first requiring the state employee to submit a request for defense. The statute is also unclear as to what happens if an employee retains private counsel first and later wishes to request a defense. The proposed change clarifies that once an employee hires private counsel, a government entity is not responsible for defense expenses, including attorney's fees and court costs. and the government entity is excused from any further duty to defend the employee. This provides predictability. Government entities will not be hit with attorney's fees and costs months or even years after a person chooses to retain private counsel. But I will note that this section does not affect indemnification. Moving to section 3. This section addresses requirements for a special verdict under NRS 41.0348. NRS Chapter 42 specifically addresses exemplary or punitive damages. So the goal of the changes in section 3 is to align NRS 41.0348 with that specialized chapter, Chapter 42. Subsection 1 of section 3 deletes the phrase "of this state." This is because Nevada tort law is applied in both state and federal courts. Therefore, a special verdict forms should be requested in both state and federal courts. The statute should not suggest that a lower standard applies simply because a person filed a lawsuit across the street in federal court when the judges are applying the same Nevada statutes. Next, subsection 2 of section 3 is not a change in the law. It simply clarifies that what NRS 42.005 and case law already establish. The clear and convincing standard of proof applies for punitive damages. Finally, subsection 2 of section 3 aligns the language with the definition stated in NRS 42.001 for exemplary and punitive damages. Section 4 addresses indemnification of state actors. So I'll start by noting that the duty to defend is broader than the duty to indemnify. Indemnity works similar to insurance, but it's the taxpayer's money in this situation. The state has a statutory obligation to pay when an employee causes an injury. And our decisions regarding indemnity are not taken lightly. Over the last 40 years, NRS 41.0349 has allowed the state to deny indemnification if an employee's act or omission was not within the scope of that person's public duty or employment, or if it was wanton or malicious. Subsection 1 of section 4 would expand the exclusions so that the taxpayers are not required to pay in 2 additional situations. First, if a person was terminated from employment or resigned instead of being terminated based on acts or omissions that were outside the course and scope of their public duties or employment. And second, if the person was held liable for the criminal act or omission that is the subject of the civil lawsuit. However, subsection 2 of section 4 gives the Attorney General discretion to still indemnify an employee in certain circumstances. Other states have given the chief legal officer this discretion and flexibility. Many times, the state wishes to appeal an adverse judgment, and by allowing the Attorney General to weigh all of the factors at play, including the best interests of the state can save money by avoiding costly retention of conflict counsel and allowing an appeal to go forward. The final section, section 5, addresses the liability of employers for intentional conduct of employees under NRS 41.745, which applies broadly to all Nevada tort claims and all types of employers. Now, the tort cap that is provided in NRS 41.035 limits tort damages against the state and state actors, but that tort cap does not apply to constitutional violations. Section 5 changes are meant to align NRS 41.745 with Ninth Circuit case law regarding supervisory liability for constitutional violations. So the two example cases that I will place on the record are Keats versus Coyle, 883 F 3rd 1228, Ninth Circuit case in 2018, and Hansen versus Black, 885 F 2nd 642, a Ninth Circuit case from 1989. And so the changes for Section 5 summarized, they are that a public official may only be held liable for constitutional deprivations if they were personally involved or there is a sufficient causal connection existing between the official's wrongful conduct and the deprivation. And so this means that a supervisory public official cannot be found vicariously liable for a subordinate's conduct. So in conclusion, I understand that there may be some opposition to this bill, but we are open to working with stakeholders, to answering questions, and to finding solutions that will best serve the citizens and taxpayers of Nevada while protecting the state budget and ensuring that the state is treated fairly just as any other litigant. Thank you.
All right, committee members, do we have questions? I'll start with Senator Ellison.
Thank you, Madam Chair. Can you tell me, how does this line with other states and how many other states are doing this?
Thank you, Senator. I cannot quantify a number.
If you
of
could put
how
your
many
name on the
other states
record. Sorry.
My apologies. It's been 2 years. Leslie Nino Piro for the record. Thank you, Senator. I can't provide a quantity of states that are doing this, but there are many other states that follow this model, in particular that provide the flexibility of allowing the official attorney to make a decision as to whether or not they will provide indemnity, even in the event of punitive damages.
Other questions from members of the committee? Okay, I have one question, and I may just not be reading it closely enough, but I wanted to clarify in Section 2 that if a person who is otherwise entitled to representation from the state doesn't choose to, or chooses to employ a private attorney at the beginning, and then later fires that attorney or can't afford that attorney, or that attorney dies, for whatever reason that relationship is severed, they would still be eligible to come back and ask for that representation from the state, correct?
Leslie Nino Piro for the record. They could come back and request representation, but the language currently existing already states that the state has the ability to say, no, you made a choice, and they would not have to retake on the representation. However, as a practical matter, particularly because this provision does not address indemnification, a government entity may have very good reason to want to retake on the representation to protect the entity's own interests in limiting liability.
Understood. Okay, thank you. Any other questions from members of the committee? Senator Krasner.
Thank you, Chair. Thank you for your presentation. I was just wondering, why do you feel that we need this bill in Nevada? Thank you.
Leslie Nino Piro for the record. I do feel that many of these changes are simply updating what is over 40, close to 50 years of older provisions providing for defense and indemnification of government employees. So to keep up with the times, to clarify certain provisions that weren't exactly clear.
Oops, okay. I don't see any further questions, so thank you very much for your presentation. We'll move now to testimony in support of SB 67. Anybody wishing to give support testimony is invited to the front here in Carson City or in Las Vegas. I don't see anybody moving to the front of the room in either location, so we will go to the phones, please, for testimony in support of SB 67.
Thank you, Chair. The public lines are open and working, but there are no callers to offer support testimony at this time.
All right, then we will go to opposition. Anybody in opposition to SB 67 is invited down to the front now in Carson City and Las Vegas. Please go ahead whenever you're ready.
Good afternoon, Allison Brazier, B-R-A-S-I-E-R, on behalf of Nevada Justice Association. We are in opposition to SB 67. It severely limits citizens' rights to bring claims against all public employees. This especially affects civil rights cases under Nevada constitutional law and federal 1983 cases. It severely impacts people's rights to hold the government accountable for employees' actions when there are bad actors involved. It also limits the requirement to provide counsel to public employees if they don't notify the government soon enough or if they decide to get their own counsel. And that occurs a lot of times if there's a potential conflict of interest or if the employee wants to employ counsel to ensure that their rights are being protected. Specifically, just going to Section 4, which is where we have our biggest concerns. Section 4, subsection 1C indicates there's no duty to indemnify and no liability for the government agency if the person was terminated or resigned and based upon the state or government's determination that the act was not within the course and scope of their employment. The attorneys on the committee and all of us here know that course and scope of employment is a question of fact for a jury to decide. So if the government is the sole decision maker regarding whether or not something was within the course and scope of employment, why would they ever find that it was within course and scope? It would be in their best interest to limit exposure and make those determinations that it was outside the course and scope. The interested party should not be allowed to make those types of determinations. It also does not account for situations where the employee is reprimanded multiple times for a bad act but is not terminated for that behavior, and it's allowed to continue until finally they are terminated, and then a course and scope decision again is allowed to be made by that government agency, not the jury, which is where these questions should be decided. Section 4, subsection 1D provides there's no indemnification if the employee has been held criminally liable. Again, this applies even in situations where bad behavior has occurred before and the employee has not been terminated. And then it finally reaches a point where criminal prosecution occurs. These are the worst offenses, and this bill would create immunity in those situations. And finally, Section 4, subsection 2, allows for situations where the state or government agency may indemnify if punitive damages are awarded. But again, that puts some of the decision-making ability in the hands of the official attorney. So the government attorney gets to decide if those requirements have been met and if it's in the best interest of the government to pay that award. Those are decisions that should be left to the boards, commissioners, other government officers, and not the government attorney who's representing that agency. So those are our specific concerns for SB 67. We have been in communication with the AG's office to see if there might be some amendments, but as currently written, we are opposed to the bill.
If you don't mind answering a question or two?
Sure.
Okay, Vice Chair Flores.
Madam Chair, and thank you for the comments. I was curious to know, have you had an opportunity to see some of the states that they're modeling some of this language off of, and have you had an opportunity to see exactly how it's been playing out there in the courts?
Allison Brazier for the record. No, we have not been privy to whatever states they're modeling this after. I mean, the biggest concern that we would have too is just conflicts that this would have with federal law, so specifically 42 USC 1983. and conflicts that these limitations would have compared to the rights and abilities to hold government actors accountable under federal law. So I think as currently written, there's probably a lot of conflict that might be presented to the courts to decide.
Thank you so much. All right, I don't see anybody else coming forward to give opposition testimony in person, so we'll go to the phones, please, for opposition testimony on SB 67.
Thank you, Chair. The public lines are open and working, but there are no callers to provide opposition testimony at this time.
All right, we will go to neutral testimony on SB 67. Anybody wishing to give neutral testimony is invited forward now. I don't see anybody coming forward in Las Vegas or Carson City, so we'll go to the phones, please, for neutral testimony on SB 67.
Thank you. The public lines are open and working, but there are no callers to provide neutral testimony at this time.
All right. Unless the bill presenters have any closing remarks, I don't see them coming forward, so I will take that as a no, and I will close the hearing on SB 67 and turn the gavel over to our Vice Chair, Senator Flores.
Good afternoon, welcome. And at this time, we'll go ahead and open up the hearing on Senate Bill 347.
Thank you so much. My name is still Melanie Scheibel. I am the state senator for District 9. I'm happy to be here today in front of you presenting SB 347. And SB 347 arose out of a conversation that I had with Officer Abel here about keeping people safe in Clark County and throughout the state, especially when they are experiencing a mental health crisis. We've been doing a lot of work over the last 8 years that I've served in this body to try to find alternatives to incarceration, alternatives to law enforcement response for people who are experiencing a mental health crisis. And still, it's important that we recognize the danger posed by somebody who may have access to a firearm and also be in crisis. And so that's where SB 347 comes in. As I'm sure this committee knows, in Nevada, a mental health crisis hold, also known as a legal 2000 or a 72-hour hold, can lead to temporary confiscation of firearms if the person is deemed a danger to themselves or others due to that mental health crisis hold. The law referred to as an Extreme Risk Protection Order, or an ERPO, allows law enforcement officers or family members or household members to file a petition demonstrating to a judge that an individual possesses a danger to himself, herself, or others. If the court determines that the petitioner has met the standard of proof, an individual subject to an ERPO must relinquish his or her guns to law enforcement and will be prohibited from possessing firearms for the duration of the order, which can last from 7 days to 1 year. Senate Bill 347 treats mental health crises like true crises, where immediate action is needed to prevent someone from hurting themselves or others. Instead of going through the ERPO process, this bill authorizes an officer who has placed a person on a mental health crisis hold to immediately confiscate a firearm owned or possessed by that person, and then requires that officer, at the time that the firearm is confiscated, to provide the person with a receipt that describes the firearm and a notice that sets forth the procedures governing the return of the firearm. The bill also requires an administrative officer of a public or private mental health facility or hospital, upon the release of a person who is placed on a mental health crisis hold, to provide the person with notice of the procedures governing the return of the confiscated firearm, maintain records related to the provisions of the notice, and inform the law enforcement agency involved in the placement of the person on the mental health crisis hold for the release of the person. The bill also requires the law enforcement agency retaining custody of the confiscated firearm not later than 30 days after the release of the person from the public or private mental health facility or hospital to file a petition with the clerk of the court to determine whether or not the return of the firearm to the person would result in a substantial likelihood of serious harm to the person or others, and provide a notice advising the person of the procedure for requesting a hearing on the matter and the potential consequences of failing to request such a hearing. Finally, SB 347 provides that if a court determines that the return of a firearm would result in a substantial likelihood of serious harm to the person or others, or if the court enters an order of default in the matter, the court may authorize the law enforcement agency retaining custody of the confiscated firearm to take certain actions relating to the retention, sale, destruction, trade, or donation of the firearm. Put another way, SB 347 fills a gap in the law. It addresses a situation that isn't necessarily contemplated by our ERPO protections and isn't necessarily contemplated by a mental health crisis hold. Because a mental health crisis hold comes at kind of this intersection. The person's not being arrested, so they're not losing the same constitutional rights that they would lose if they were going to be incarcerated, and so a law enforcement officer does not have the same ability to simply remove a firearm the way they would if someone was being arrested. But on the other hand, this person also is being encountered and found in a situation that is not akin to where we normally see an ERPO or an extreme risk protection order sought and granted. In an ERPO, you might have a situation where a family member, a household member, here is a person making threats, here is a person talking about suicidal ideation and picks up the phone to try to get that ERPO in order to remove the firearm. That's not this situation. This is a situation where the very first encounter is between a law enforcement officer and the person who is in crisis. So it doesn't really fit the fact pattern that we would normally see for an ERPO. It doesn't make sense for that officer to get on the phone with a judge and get an ERPO because the officer is already there. They're already in the place where they need to be, talking to the person they need to talk to, where the firearm is that they need to confiscate. So the bill fills that gap and says where we have somebody who is in a mental health crisis, who has already made contact, or law enforcement has already made contact with them, that law enforcement officer can remove a firearm from their possession at that time, and it provides the due process necessary to keep that firearm until such a time as it is safe to return it to the person from whom it has been confiscated. And at this time, I'd like to turn it over to Officer Abel to give some more context and to help me explain the bill.
Good afternoon, Co-Chair Flores, members of the Judiciary. I'm going to thank Senator Scheibel for hearing my conversation and bringing this bill. She covered it perfectly. The intent of this bill is not to take every firearm that's in the home. The intent's not to go through safes or under mattresses or dig through drawers. The intent is to take the firearm that's in the immediate vicinity of the person, whether it be on their person out in public or in their home, not locked away. We've had officers, because as of now, we've had officers who respond to these mental health crises where somebody has threatened suicide. We're able to luckily get them out and get them to the hospital where they go, and then we're left with having to confiscate this firearm for safekeeping. And a lot of officers have called us and said, we're not comfortable. We feel like it's a violation of the Fourth Amendment. That's literally where this bill came from. I've heard from stakeholders in the PD's office and the courts that this process can become arduous as far as the 30 days to have a court hearing in order to determine if they can get their firearm back. So I know there's amendments coming, and I'm obviously willing to work with any stakeholder that wants to help us, frame this bill in a way that can be acceptable so that it protects the person who's under the mental health hold and the officer and the departments. So with any questions, I thank you again. Thanks so much.
And thank you both for the presentation. We'll start off with Senator Ellison, please.
Thank you. Bet you didn't know I could find that button, huh? Madam, I do have a question, or maybe the police can answer this. Isn't it already in law if an officer shows up on duty and somebody's got a weapon and there's a mental problem, divorce or alcohol or whatever? Isn't it already, you don't have to call a judge. You can put that person under arrest, can you not?
Depending on the situation. Oh, excuse me. Sorry. For the record, my name is John Abel, represent the LVPPA. If they've committed a crime, absolutely. But suicide isn't a crime. So that's where the issue lies, is that threatening suicide isn't a crime. And so our officers are having a difficult time taking those firearms. Because listen, most cops like myself believe the Second Amendment. We don't want to infringe upon those rights, but we also want to make sure that the person in the mental health crisis and their families are protected until such time that person is well enough to own their firearm.
Follow up, sir?
Please follow.
Situations as police commissioner where I've seen this happen. And there was other people in the facility, and finally the chief showed up and he put him under arrest. They had to take him to the ground, put him under arrest. But the other thing was that it would have kept on going while they tried to get a judge, and somebody probably would have got shot. So that's why I was asking this question, and thank you.
Yeah, thank you.
Members, any additional questions? Senator Krasner, please.
Thank you, Vice Chair Flores. Thank you for your presentation. Is there a current procedure for this scenario?
For the record, my name is John Abel, representing the LVPPA. The current procedure is whatever firearm is present, we take for safekeeping, which can violate the person's Fourth Amendment rights. We can ask for consent, take the firearm, but that often doesn't. Either we don't have time to ask consent because they're being loaded into the ambulance to go to the hospital under the mental health hold, or if it's forgotten, ask consent, or they don't give consent. Even if they don't give consent, we still need to have the ability to hold that firearm for safekeeping. So yes, the procedure is now we take the firearm for safekeeping, but many of our officers believe that it violates the Fourth Amendment.
Can I follow up, sir? So currently in a situation, one spouse calls about the other spouse. Oh, I'm worried. My spouse has guns in the house. I'm concerned. They're angry. They might be suicidal. They might be violent. Police come and they can take the gun current law, but then they have to give it back after the person is released and adjudicated suitable to get the firearm back, or how's that work?
For the record, John Abel with LVPPA. So currently, so I was in patrol for 13 years, and currently how I would handle that situation is if I had a call of a wife or a spouse calling on their spouse saying, hey, I think my spouse is suicidal and we have guns in the house. When I get there and complete an investigation, the first thing I would find out is, did they actually threaten to commit suicide? Was there an active threat to commit suicide? Or was it just general, were they talking about it? And was there a threat to use the firearm? And depending on what firearm it is, if I determine that that person needs to be held under Legal 2000, then yes, I would make the consideration whether or not I would take the firearm. If I could leave the firearm in the custody of the wife where she could lock it up, I might do that. Or I would ask for consent. Hey, would you mind if we take this firearm for safekeeping? We fill out a property report. It's a duplicate copy, and we would hand the pink sheet to the spouse to hold on for the gun owner. If I do take the firearm for safekeeping, and then when we get approved through our firearms section at LVMPD to release that firearm back to them at a later date.
Please follow up.
Thank you. And so now with this bill, same scenario, the spouse calls and says, they might be suicidal, they're waving a gun, they might hurt me and my child. Law enforcement comes out. With this bill, they can take the firearm, and then the person goes into the institution and they're decided they're okay, they were just upset because they lost their job or something. They have to now go through a court hearing to get the firearm back. Is that correct?
For the record, John Abel with LVPPA. Yes, that is how the bill is written. I do expect amendments to come, later date to solidify what that process is gonna look like. But as of now, that is how the bill is presented.
Thank you.
You're welcome.
Members, any additional questions? Senator Hansen, please.
Thanks, Mr. Vice Chair. Obviously, there are other tools that can be used to commit suicide. Now, if you guys find somebody's going to use a knife to slit his wrists or hang themselves with a rope or whatever, do you confiscate those typically? And if you do, what is the procedure for the individuals to get those things back?
John Abel, for the record. I'd have to do some research on that. I don't think we would confiscate a rope. I mean, depending. I was always trained. That if I come upon someone who's committed suicide with a rope, to make sure I keep. I'm going to treat it as a crime scene, obviously, because we don't know the details behind what happened. So we cut the rope and keep the knot intact, things like that too. So I've never been in a situation where we had to confiscate a rope after a suicide attempt or a knife, but I could see us doing that though.
Okay, I was just wondering the procedure to get it back. Rope, obviously, it's unlikely that they're going to harm somebody else, but knives, like a firearm, definitely something that could, lots of murders committed in domestic situations with knives and hammers and things like that that could theoretically be doing that. Because I realize this bill is tailored to firearms. I'm just kind of wondering what the other procedures are. Knives obviously don't fall under the Second Amendment, so there are some different things. But I'm kind of wondering how you guys do it.
John Abel for the record with LVPPA. It would be just like any other property that we confiscate for safekeeping. We would fill out a property report, describe what we're taking. We would impound it as property for safekeeping, leave a copy of the report with the owner, and then they can get it back at a later date. By getting it approved, obviously, there's numbers on our property reports to call and follow up, and then ultimately when it's released, they go to our evidence vault with the appropriate paperwork, and they can retrieve their item.
Okay, well, does that require a 30-day window of time? And because you're kind of making it so to get the firearm back, you have to go through a judge, basically, to get it back. Your current procedure that you just described, does that, like if I want to come back, and get my knives back or some other serious weapon like that, does that currently require going before a judge before that property file is given back to the individual who you had taken it from?
John Abel for the record with LVPPA. I don't believe so, sir. That those types of things, property other than firearms, don't require to go before a judge. No, sir.
Okay, well, that's kind of my concern. It's like, okay, there's other things besides firearms. Firearms, unlike knives, do have a Second Amendment protection. Getting it back under this circumstance in this bill would require essentially a judge's formal release. If that isn't required in other types of weapons, which could also be used to harm individuals in a household or whatever, it seems like the standards should be the same. That's kind of what I'm getting at.
Yes, sir.
Melanie Scheibel for the record. I also do want to point out that in subsection 4, subsection A, which is at the very top of page 3 of the bill, it's not just the judge has to make a determination, but the officer or the agency that confiscated the firearm actually has to apply. They have to file a petition to keep the firearm. If they do not fill out the petition indicating that the person is a danger to themselves or others, then the firearm would be treated like any other piece of property. It would be automatically re-released to the person from whom it was confiscated. So it doesn't shift the burden to the person from whom the firearm was confiscated. The burden stays on the police to affirmatively file that petition described in subsection A at the top of page 3 saying, we confiscated this firearm and we believe this person to be a danger to themselves or others, and we want to keep this firearm for a certain period of time or an indefinite period of time. And then that triggers the person who's been held on the mental health crisis hold their right to contest that determination and have a hearing in front of a judge.
Okay, good. Thank you for that clarification, because I kind of read it where it's automatic. So this would be if the officer determines, look, yeah, I can't give this guy back the gun because he's going to shoot himself or whatever, shoot somebody else. Okay, well, that makes more sense. The other question is, how frequently do you guys run into situations like this that involves firearms? And also, you mentioned twice the Fourth Amendment violation. What is the violation in the Fourth Amendment specifically that you're talking about?
John Abel for the record with LVPPA. So when we encounter someone who is suicidal, so typically these things would happen, either they call themselves or a family member calls and officers arrive at the house. And I can only go back from what I experienced. I haven't been in patrol since 2018, so I'm sure procedures have changed a little bit. But on the calls that I went on, typically it was someone, hey, my husband, my wife, my son is suicidal. They threaten to use a firearm, and we respond, well, suicide isn't a crime. So typically, in order for us to confiscate, so if the gun had been used in the commission of a crime, it would then be evidence. We could then collect it as evidence, which wouldn't violate the Fourth Amendment. Suicide isn't a crime. So where we have issues is we're taking these firearms for safekeeping, but suicide isn't a crime. And this sounds far-fetched, but so just bear with me. I have dealt with people who have been under a legal 2000 hold, which doesn't always require a 72-hour hold. It's up to a 72-hour hold. And in my experience, they go to the hospital. They sit on the gurney in the hospital hallway for sometimes 12 hours before they're seen by a doctor. They're not seen. They're sitting in the hallway. And from my experience, they're like, I don't want to be here. I was under, I was suicidal then. I'm not anymore. I'm out of the situation I was in. And once they're seen by a doctor, they know what to say to not be under that, additional two-day hold. And then they get released and they're right back into the situation where they were at their home. And I've been called back out before where I've legaled somebody, and the next shift I'm right back out there dealing with the same thing. They're not always firearms. It might be something else, or just I'm going to take pills or whatever else it is. But the 72-hour hold isn't always a 72-hour hold. And what we're trying to do is, let's say they get out, before 72 hours, and they go home. We've taken their gun for safekeeping. It's the only gun they have in the house. Someone breaks into their home, and they now don't have a gun to defend their home because the police took it under the safekeeping, policy that we have. In our opinion, we could be held liable for violating the Fourth Amendment, taking that person's firearm when they were suicidal.
Okay, so what you're saying then is because suicide is not a crime, you would need a search warrant and probable cause before a judge under the Fourth Amendment to confiscate that firearm. Is that what you're saying, basically?
For the record, John Abel, yes, sir.
Okay. All right. Yeah, well, I don't want to do anything that would hamstring the officers in the field that have to deal with some pretty horrible situations, which obviously you experienced. Kind of do a balancing act, too. And so thank you for the clarifications on the bill. I think it makes a lot more sense now that essentially it would be up to the officer to show to a judge that that property file should not be given back to this individual. Otherwise, it will normally be turned back over to them when hopefully they get into a better state of mind. Is that kind of where we're going with this? Okay. All right. Thank you, Mr. Vice Chair.
Members, any additional questions? Senator Krasner, please.
Thank you, Vice Chair, for letting me just ask one more time. So you just said 3 times committing suicide. Suicide's not a crime. So on what basis would law enforcement even go out then if it's not a crime?
Public safety of the family. If there's family inside the residence, things like that, we would go. I know there is some. Sorry, John Abel for the record, LVPPA. I know there is some arguments now that officers should not respond to single suicidal subjects where the only person's life in jeopardy is the person who's trying to commit suicide, because I know that there's I don't know the court case. I can't quote it, but we've encountered where officers get out there and then we're accused of creating the situation that made us use deadly force against the person who's trying to commit suicide. Because sometimes people don't have I hate to say, the guts to do it themselves. That sounds terrible, I know. And so they point the guns at us, and then we use deadly force to stop the threat. So there is some sentiment now. There's no family that is involved inside the home, then we wouldn't go, right? But most likely there's times when they're out in public. They could be on a sidewalk, at a bus bench, inside a supermarket. I've encountered suicidal subjects, all over, called for, parks, grocery stores, things like that. But for public safety, obviously, we're going to go public, safety of their family and their children inside the home as well.
Next, we'll go to Senator Wynn, please.
Thank you. Are there times, though, that do police officers still not go out and do wellness checks? If someone was to call and say, oh, I'm concerned about my neighbor in either a suicide or the no responsiveness, there are other circumstances where police officers go out to the scene and encounter people that are in crisis. Isn't that right?
John Abel for the record with LVPPA. That is correct. If an officer gets called to the scene of a welfare check, hey, I haven't heard from my neighbor in so many weeks, there are steps and procedures that we have to follow before we maybe get a locksmith or something like that to go inside the residence to check. A lot of it is talking to the neighbors. When's the last time? Silly it sounds, checking the mailbox to make sure, see how much mail is piled up. Calling a loved one if we can get a hold of a loved one to say, hey, when's the last time you encountered this person? After we've exhausted everything to make sure that nobody's seen this person in a number of days or weeks, typically what we've done in the past is called a locksmith. Locksmith opens the door, and then we clear the residents to see if they're in there. But before that, we're knocking loudly, announcing police department to try to. We'll check, go around. We'll check for open windows. I've encountered where I've been out to a welfare check and you walk around. There was an older person who lived in Sunset East Summerlin, and you could see them. They were deceased by the kitchen table. They died of a medical emergency, things like that. So yes, we respond to these types of calls all the time.
Thank you, Vice Chair.
Members, any additional questions? Seeing none, thank you both. I'd like to invite you to sit back in the gallery. And at this time, we'd like to invite those wishing to testify in support, if you could please come forward, either in Carson City or Las Vegas, for Senate Bill 347. Seeing none, BPS, do we have anybody wishing to join us over the phone in support of Senate Bill 347?
Thank you, Chair. If you would like to offer testimony in support of SB 347, please press *9 now to take your place in the queue. There are no callers wishing to offer support testimony at this time.
Thank you. At this time, I'd like to invite those wishing to testify in opposition to Senate Bill 347, if you could please come forward. Good afternoon, welcome. Whoever wishes to go first.
Thank you, Vice Chair, members of the committee. For the record, Mike Cathcart, representing the City of Henderson. We're very, very supportive of the intent of the bill, and we will hopefully be supportive of this bill once amended. I just want to thank Mr. Abel for all the time he spent with us talking about some of the details in the bill. We're just going to be asking for a couple clarifying amendments, and then hopefully we will be supportive. Thank you.
Thank you for joining us. Good afternoon, welcome.
Good afternoon, Senators. My name is Sean McCoy, SEANMCCOY, and I am from Senate District 15 in Reno, Nevada. I've been a licensed Nevada attorney for nearly 20 years, with over half that time working in mental health law. I'm also passionate about the legislative process, and that's why when it came time to update Nevada's 40-year-old mental health crisis laws, I was tasked with creating the initial draft language in 2019 and in 2021. But I don't want you to think that that work was done alone. On the contrary, it was the culmination of a multi-year statewide collaboration, and we did it that way for two reasons. First, we wanted to make sure we had buy-in from every Nevada stakeholder involved in the mental health crisis process: judges, legislators, lawyers, doctors, nurses, hospitals, therapists, law enforcement, mental health rights and advocacy groups. We excluded no one. Second, we wanted to make sure we got the language right, because, as I'm sure we'd all agree, in legislation, details matter. Unfortunately, it is my opinion that SB 347 misses the mark. Not only is it disconnected from how mental health crisis holds are actually processed in Nevada, but it raises significant HIPAA and due process issues. I've submitted an in-depth analysis of the issues that I expect to be on Nellis, but let me give you just a taste. Everyone placed on a mental health crisis hold in Nevada is placed the same way. In other words, they all enter the process through the same door. They do not, however, all leave through the same exit. As drafted, the law enforcement notification provision of SB 347, which triggers the petition process, only contemplates people on a mental health crisis hold leaving through one door. Not only does the provision require disclosure of protected health information covered by HIPAA, but it misses the fact that not everyone placed on a mental health crisis hold is released the same way. What happens to confiscated firearms when a person placed on a mental health crisis hold is released through another door? Now, I didn't drive all the way down here today just to complain about a bill muddying up my favorite chapter of the NRS. I'm also here to offer my help in making it work. The offer's on the table. Thank you for your time and consideration.
And thank you for joining us. Good afternoon, welcome.
Good afternoon, Vice Chair Flores and members of the Senate Judiciary. Paloma Guerrero, PALOMAGUERRO, on behalf of the Clark County Public Defender's Office. I do want to thank Officer Abel for speaking with us and hearing out our concerns about the bill. We definitely want to tighten up the language to fit the intent of the bill for any firearms within the direct vicinity to be confiscated, because we definitely don't want a complete search of the whole house coming from the bill. Also, with the confiscation of this property without due process, the risk of violating gun property rights of others who are not in a mental health crisis, for example, if the gun belonged to someone else that's in the home. And then whether a person in crisis is in the right state of mind to be noticed on their legal rights regarding property, and the ability to request a hearing may be restricted by access. I think the previous speaker kind of touched on people leaving these situations differently, and it could be the case that someone entered an inpatient program and doesn't have access to a computer or the court to request a hearing. But we're looking forward to working through these issues with Officer Abel and Chair Scheibel. Thank you.
Thank you for joining us. Good afternoon.
Good afternoon, members of the committee. My name is Keely Hopkins, and I'm the State Director for the National Rifle Association, here today on behalf of our members in opposition to the bill. Our main issues with the bill are largely focused on due process, as you've already heard from others today. As for due process, Senate Bill 347 permits law enforcement to seize a firearm from an individual without a criminal conviction, without being adjudicated mentally ill, or without even having a hearing. A foundational principle of the American judicial system is to assure that an individual is entitled to due process, notice of accusations, an opportunity to appear at a hearing, and to present evidence in his or her favor. And this should all occur before an individual is subject to a seizure or a removal of a right. Under the proposed legislation, however, law enforcement would be authorized to seize a firearm from an individual being taken in for a mental health hold. Regardless of the outcome of such a mental health evaluation, Senate Bill 347 would allow law enforcement to retain the individual's firearms for at least 30 days, and an individual might even be forced to petition or appear in court and have a hearing to get their firearms back. Between the seizure occurring with a very weak evidentiary standard to an individual potentially having to appear in court to have their firearms returned, even if the mental health hold determined they're not a danger, we do not believe this is an adequate protection of due process, and for those reasons, we urge you to oppose the bill.
And thank you for joining us. Good afternoon.
Good afternoon, Vice Chair Flores, members of the committee. Jason Walker, JASONWALKER, representing the Washington County Sheriff's Office, as well as the Nevada Sheriffs and Chiefs Association. Have had conversations with the senator and stakeholders, and I understand the intent of this bill. Each one of these incidences are similar but different. I believe it could be solid framework for safekeeping of firearms, just need to work out some infrastructure concerns. We are definitely open to continued conversations regarding this bill.
Thank you for joining us. Good afternoon.
Good afternoon, members of the committee. For the record, Thomas Morley, representing the Nevada Firearms Coalition, that's spelled THOMASMORLEY. I'd like to echo the comments by the NRA. My client has the same concerns, that it violates constitutional amendments, or provisions rather, and we are in opposition to this bill currently, but I'm willing to go work with Mr. Abel on it. Thank you.
Thank you for joining us. Good afternoon. Welcome.
Tanya Freeman, TANYAFREEMAN. I see several problems in the bill that would involve HIPAA. I also see an extra burden on law enforcement and the courts that are currently already overburdened in a lot of cases. If you're arrested on a Friday night, you have to be arraigned the following day. You can't wait till Monday. That's one of the things that I've seen. So I definitely disagree with this bill, and I'm totally in opposition. Not to mention the fact that it is also, in my eyes, a clear violation of the Second Amendment and the Fourth Amendment.
Thank you for joining us. Good afternoon. Welcome.
Good afternoon. My name is Lynn Chapman, and I'm the State Vice President of Nevada Families for Freedom. Most of my questions were answered to a certain extent, but my question was a couple of questions. If a person is taken away and given a receipt and procedures, what happens if it's longer than a 72-hour hold? What happens if they go into a facility for a longer period of time? Would they still be able to get their firearm back? For one, and another question, I had a question about where would the firearms be stored when they're taken, and apparently there is room at the police departments or whatever. But what if the firearm ends up missing? when they go to get their firearm back? What happens then? I'm just wondering.
Thank you for joining us.
Thank you.
Good afternoon.
Good afternoon, Mr. Chairman, Vice Chair, and members of the committee. My name is Janine Hansen. I'm here as the state chairman of the Independent American Party. We have many of the concerns that have already been expressed, due process, but one thing I noticed on page 3, when it goes down the process for returning a person's firearm, between 7 and 8, in 7 excuse me, it talks about what happens if they aren't given an opportunity, if the judge decides they shouldn't have their gun back. But nowhere in the bill can I find how the court is supposed to return the firearm if they are not considered, if they're considered that they can get their firearm back. I don't see that in the bill. Only the one part that they can maintain the gun and not return it, but not how the court returns it. So perhaps that one little piece needs to be returned. And I am concerned about the 30 days and the 30 days as well. Thank you very much.
And thank you for joining us. At this time, I'd like to invite anybody else wishing to testify in opposition to Senate Bill 347. Seeing none, BPS, do we have anybody else wishing to join us in opposition over the phone?
Thank you, Vice Chair. If you would like to provide testimony in opposition to SB 347, please press star 9 now to take your place in the queue.
Good afternoon, everyone. Thank you so much, Chair. Cyrus, Hojjaty. I stand in opposition. I will echo the comments made by the previous speakers, especially the Sheriff's Association. I appreciate the intent, but I will remain in opposition. Ditto. Yield.
Thank you for joining us. Next caller in opposition, please.
There are no further callers to provide opposition testimony at this time.
Thank you. And lastly, we'll invite those wishing to testify in the neutral position to Senate Bill 347. If you could please come forward, Carson City or Las Vegas. Seeing none, BPS, do we have anybody wishing to join us in the neutral position over the phone?
Thank you, Vice Chair. The public lines are open and working. However, there are no callers to provide neutral testimony at this time.
Thank you. We'll go back to our chair to do any closing remarks.
Thank you, Vice Chair Flores. At least I didn't get anybody in neutral. I do want to thank everybody for their work on this bill, and I have spoken with most of the people who came up in opposition, not all of them, and absolutely, I am open to working on this bill and developing a more specific policy. I certainly care very deeply about everybody's due process rights and want to ensure that they're protected, and I hope that we'll be able to work together to come to an agreement on an amendment for the bill that works for all the parties.
John Abel for the record, LVPPA. To answer the lady's question, if we lose your firearm, I mean, things get lost, correct? We refer them, in Metro, we have risk management. Anytime we break or lose something, we refer them to risk management, and most likely their firearm would be replaced. So that's all I had. Thank you. Thank you for the time. Appreciate you.
And thank you both for joining us. With that, we'll go ahead and close out the hearing on Senate Bill 347. And next, we'll go to Senate Bill 407. Whenever you're ready.
Good afternoon again. I'm still Melanie Scheibel, Senate District 9. I am delighted to be joined by my intern Soraya Bonner this afternoon to help me present SB 407, which is a product of the Joint Interim Judiciary Committee this session, or this interim, and I will turn it over to her to walk you through the bill.
Good afternoon, Vice Chair Flores and members of the Judiciary Committee. I am Soraya Bonner, Soraiabohner, and I am Senator Scheibel's intern. I am pleased to present for your consideration today Senate Bill 407, which revises provisions relating to legal representation for indigent persons. This bill was requested by the Joint Interim Standing Committee on the Judiciary. I would like to begin by providing little background on where we are with indigent defense services in Nevada's rural counties. To do so, you must go back to 1963, when the United States Supreme Court ruled in Gideon v. Wainwright that the Sixth Amendment of the United States Constitution holds that anyone charged with criminal offense is entitled to the right to competent counsel at state expense. In 2018, plaintiffs on behalf of themselves and all other indigent defendants in the rural counties filed an action against the state of Nevada, challenging the constitutionality of defendants' policies and practices of indigent defense in the rural counties of Churchill, Douglas, Esmeralda, Eureka, Lander, Lincoln, Lyon, Mineral, Nye, and White Pine. Ultimately, without any admission of fault or wrongdoing, the parties wished to settle the action to avoid cost, difficulty, and the uncertainty of further litigation. In August of 2020, the judge presiding over Davis versus Nevada approved a stipulated consent judgment. The requirements from the judgment are set out in 3 parts. First, the state must eliminate economic disincentives to indigent defense providers, providing effective representation. Second, the state must establish minimum standards for indigent defense and provide training and resources to indigent defense attorneys. Third, the state must require uniform data collection and reporting on indigent defense services. Fast forward to the 2024-2025 legislative interim, where Marcy Ryba, Executive Director, Department of Indigent Defense Services, testified at the February 23, 2024 meeting of the Joint Interim Standing Committee on the Judiciary that despite the state's recent efforts, the greatest challenge they are facing while trying to meet the requirements from the judgment is the shortage of indigent defense providers in rural communities. To help alleviate ongoing issues, at its final meeting and work session on August 30th, 2024, the committee voted to move 2 recommendations forward in the form of a bill draft request to first allow an alternate public defender and a post-conviction attorney to handle post-convictions in-house rather than by an hourly appointed counsel. And second, allow a deputy state public defender employed by the state public defender to maintain a private workload by removing the prohibition in subsection 2 of Nevada Revised Statutes 180.030. Next, with the pleasure of the Vice Chair, I would like to provide a section-by-section overview of the bill. In total, it creates the Office of the Alternate State Public Defender within the Department of Indigent Defense Services to counsel and defend indigent persons under certain circumstances, including, without limitation, if the county public defender or state public defender is disqualified or otherwise unable to provide representation. Section 9 creates the Office of Post-Conviction Counsel within the Department of Indigent Defense Services to prosecute appeals and other post-conviction remedies on behalf of indigent persons under certain circumstances. Sections 4 through 8 and 8 through 14 prescribe the qualifications, powers, and duties of the alternate state public defender and the post-conviction counsel, respectively, and make various other changes relating to the provision of legal services by each officer. Section 18 authorizes the state public defender to enter into a contract with the alternate state public defender or post-conviction counsel to provide representation for indigent persons under certain circumstances and provides that services must be performed under the supervision and the control of the state public defender. Section 19 revises certain qualifications of the members of the Board on Indigent Defense Services. Section 20 through 23 revise the duties of the board, department, and certain employees of the department to require them to perform certain duties relating to the oversight of post-conviction services in this state. Section 24 provides that the privilege for confidential communication between a client and the client's attorney is not waived if a disclosure is made to the department or its designee for the purpose of submitting a complaint against an attorney providing post-conviction services. Sections 2 and 15 define the term post-conviction services for the purposes of this bill and other certain provisions of existing law governing the provision of legal representation to indigent persons. Sections 16 and 17 remove the prohibition of the state public defender and any deputy state public defender employed in the office of the state public defender from engaging in the private practice of law. There is a fiscal impact to make these changes, and there is no doubt that if this bill were to pass, it would be referred to the Finance Committee where that could be discussed further. That concludes my presentation of the bill. Ultimately, this bill will help the state meet its obligation to provide competent counsel for indigent Nevadans who live in rural counties. Thank you for your time today.
And Vice Chair, I did notice that the Director of the Department of Indigent Defense Services is here with us today, and I'm not sure if you wanted to make any comments or come down and help answer questions, not to put him on the spot, but we've been scheduling like crazy, and coordinating those schedules has been a challenge, so I appreciate you being here, Mr. Handy.
Sure, thank you for having me. Peter Handy for the record, Peterhandy, the Executive Director of the Department of Indigent Defense Services. I'm happy to answer any questions that any of the senators might have.
Thank you. We'll start off with Senator Nguyen, please.
Obviously, setting up a new, I guess, division and office to handle this. Ultimately, do you know how much you spend currently on rural post-conviction relief? And whether or not this would actually be a cost savings to have those counsel employed?
Peter Handy for the record. So we don't track it based on the county. I mean, there is a tracking. I don't know about the rural specifically. My understanding is this encompasses the state. Most of the post-conviction cases come out of Clark County, as you might predict. That's where the majority of the costs are. We're on track this year in the fiscal year to spend about $2.2 million on post-conviction counsel expenses. That's approximately what's being proposed in the fiscal note for that office expense. It's expected that over time that there would be realized savings as the cost for hourly rate for appointed counsel across the state would continue to increase as it has in the last couple of years versus the rates that are paid to employees, and having those costs more in-house and controllable and knowable.
May I follow up?
Please.
I see here in section 17, it also allows those same state public defenders to engage in private practice of law. Would they be able to practice in the same area of law, or are we indicating that it would be other types of law? I would be worried that they would be drawing down a salary and then also taking any extra cases that maybe this office would not be able to handle for post-conviction.
Melanie Scheibel for the record. Thank you for your question, Senator Nguyen. We did discuss this during the interim committee meeting where we discussed this proposal, and the idea is more what you said. It would be other types of law. We're finding it is so difficult to employ people in rural areas who are even willing to do indigent criminal defense that when we also tell them, and now you can't help your grandma with her will, and now you also can't review your cousin's employment contract, and you can't take on that one car accident case that happened in your city last year for the plaintiff, then it becomes even harder to get people to take those jobs. And so certainly the department would have rules and procedures around conflicts and around what types of outside employment those public defenders and alternate public defenders are allowed to have, but that would be contractual as opposed to statutory. The statutory change is just to allow for that possibility to try to attract some more qualified and competent legal counsel to even serve in these roles.
And if I can have one last question.
Please.
As proposed, obviously there's a fiscal note and this would go to a fiscal committee, but I see that there is like a recommendation for a certain number of attorneys to be in there. How did you determine then that would be the appropriate amount of attorneys to cover the workload that's currently existing? Because I'm assuming you have an idea of how many cases there are and whether or not this would be sufficient as it's stated.
Peter Handy for the record. Yes, so this was originally proposed in the agency's requested budget way back when. This was contemplated by my predecessor and others in the office based on the amounts that we're paying to contracted counsel. The number of contracted counsel that typically take these cases, since we're reviewing all the billing for those attorneys coming through and paid for by the state. We see how many attorneys are actually taking these cases. There aren't that many. It's a very highly specialized area of law. There aren't a lot of attorneys practicing in this field, and when this initial proposal was made, this is the estimate we came to that we think would meet the needs to cover all of the cases for which counsel is currently being appointed. If for some reason, right, judges change their mind about how counsel is appointed, obviously things could change.
Senator Hansen, please.
Thanks, Mr. Vice Chair. How many, there's a lot of specifications in the bill about the number of cases and all that. Do you guys already get that data currently, something similar to that? Because what I'm kind of wondering is, I represent a bunch of rural counties, and some are very small, Eureka, I don't represent Esmeralda or Lincoln or some of the really, really small counties. How many cases are we talking about in a normal year where there actually is a need for indigent criminal defense? Is it, are we talking, one per year per county on average, or you have any idea? How big is the problem, I guess, that we're trying to solve is what I'm kind of getting at.
I guess it depends. I don't have the data right here in front of me. I could certainly get you the number of cases that we expect or that we are seeing in each county. It varies greatly by county. For post-conviction services, generally the first instance has to be brought in the district court for which the conviction was had. So in like Esmeralda County, you could see a post-conviction case coming back. The numbers, in my understanding, in many of those counties, it's a very low number. We see significantly more in Clark County, Washoe County, but there are a significant number coming out of Elko County, Carson City, Douglas County, Lyon County, because there are a substantial number of cases filed and a substantial number of convictions had. For example, I think we're estimating something like 1,750 cases on average per year, criminal cases where there are indigent defendants in Nye County. Nye County is a fairly large county, certainly geographically, but also by population. But just kind of gives you an idea of the number of cases that could potentially result in some post-conviction cases down the line.
Okay, this bill is kind of designed, doesn't include Clark and Washoe, does it? Or is that part of it also? I thought this was mainly geared toward rural, small counties that don't have their traditional public defender's offices.
So my reading of the bill is that for post-conviction, that would be statewide. For the alternate public defender, that office would be only for rural counties.
Oh, okay. I missed that. Thank you for that clarification. Okay, well, it sounds like a good idea. We just had a bill, last session or 2 sessions ago, to try to expand the number of public defenders basically in rural areas, and it is difficult to find people that qualify and are willing to go work in, often really isolated spots with, especially people that are indigent. So it's kind of an interesting dilemma, trying to make sure they have their legal protections as the Bill of Rights requires. So, all right, well, thank you, Mr. Vice Chair.
Senator Ellison, please.
Yeah, we had a situation down by Ely years ago, a couple of years ago, where we lost a patrolman. And I think they tried him under mental and indigent. I'm not sure, but would that fall under this? That was a murder case. Could you give me an idea of what kind of crimes these are? Give us an idea of what we're looking at.
Sure, Peter Handy for the record. So I'm going to kind of split into 2 buckets since there are 2 kind of main parts to this. First is that alternate public defender's office, right? So right now, the Nevada State Public Defender's Office provides frontline indigent defense services in White Pine County, including the city of Ely. And they handle whatever crime comes through the door for an indigent defense client. So that could be something from a simple trespass to a murder case that comes about. Certainly because of the prison, we see a lot on the higher end side of cases coming out of Ely. For the post-conviction case, these tend to be people who have already been convicted of crimes. So these are persons who have already been convicted. They may be in prison, they may be out of prison in some circumstances, and seeking some relief based on some circumstances that might arise during their trial, like as ineffective assistance of counsel, or maybe they had a due process issue come up during their case, or there's something wrong with their terms of imprisonment and they're raising those issues. Those are the kind of cases that would be addressed by that post-conviction counsel. They're not providing defense to a trial level case that's going on, if that makes sense.
Yeah, it does. Follow up, sir?
Please follow up.
Would this be like reimbursement? Any of this could be as a reimbursement to one of them small counties? If they had to pay somebody to come in there?
So right now, for the alternate public defender's office, as proposed, the way the system works now, right, is if a county is opted into the public defender's office, the state public defender's office, they pay up to their maximum contribution and no more. The rest of that cost for indigent defense services is covered by the state. The same thing is contemplated for the alternate public defender's office. So effectively, they'd be providing a conflict service. So right now, they're either contractors or appointed counsel that are paid for by the state to provide that second-tier representation. So if the Nevada State Public Defender's Office has a conflict, maybe there's two defendants in the case, they might have adverse interests. The state public defender can't represent them both, and the alternate public defender could then either contract with an attorney or represent that second defendant in the action so that everyone has representation. And that wouldn't be at an additional cost to those counties.
I appreciate that, because I didn't know this even existed until today.
Yeah.
So,
And Melanie Scheibel, for the record, just for fun, Senator Allison, I am one of those contracted appointed counsels. And so I have in my inbox right now, the Department of Indigent Defense Services looking for somebody to represent a defendant in Elko County who is charged with 3 counts of child abuse. There's someone else in Elko County they're looking to represent who is charged with 2 counts of owning a firearm by a prohibited person, along with defacing, altering, obliterating a motor vehicle identification, and buying or receiving stolen property. They're also looking for somebody in Elko County to represent a different person who is accused of child abuse or neglect. They're also looking for another attorney to represent a different person who is also accused of child abuse or neglect. And finally, they're looking for somebody in Elko County to represent yet another person who is charged with child abuse or neglect. That's just in my inbox right now.
question, sir? Doesn't our public defender or the district attorney pick up any of them cases?
So, Melanie Scheibel, for the record, the Elko Public Defender has probably already picked up one of those cases, and those might be co-defendants. So, 3 or 4 people are accused of abusing the same child. It might be that they're related family members, and so the public defender is unable to represent any of them, even though the cases are different, because by representing one of them, they would learn information that would be adverse to another client. It could be that they've previously represented somebody else in the case. There are a lot of reasons that, the public defender might be conflicted out of representation, and that's where the Department of Indigent Defense Services comes in and helps to try to connect those clients, those people who have been accused of a crime and are legally entitled to an attorney. DIDS helps connect them with an attorney free of charge to the person.
Thank you very much.
Senator Nguyen, please.
You kind of answered this, but obviously I've done this type of work as well, so I understand some of the problems. And then sitting on IFC, you all get to come back and see us every single month. Would this alleviate that need to have to come back and seek funding, additional funding, or having those transfers of funds, or would you still have some of those same issues?
Peter Handy, for the record, I don't know. We have asked for funding in addition to existing funding for things like post-conviction, certainly over the past year because the costs have significantly increased to the state. Those have been paid for out of a bucket that's allocated to the Nevada State Public Defender's Office. This would just kind of reutilize those funds to be used to pay state employees, state services, rents, all of those kind of associated costs, instead of paying them to contractors. For the alternate PD's office, it may support if the cash is in the bucket, right, that's for the alternate public defender's office, then we don't have to ask for that funding should those contractors be needed. They would already be contracted within the office. I'm trying to answer your question in a way that makes sense, but if for some reason like the Davis monitor says, hey, these things are needed for Davis compliance and we're asking for a different reason, that's something I can't anticipate, right, needing to have to ask for in the future. So I think certainly with the way that our budget as proposed has come through, we're far less likely to need to make asks of IFC going forward anyways, especially with some amendments that I've heard are coming down. We shouldn't have to be making those asks for compliance for the things that we've been making in the last couple of years. So it should alleviate that. Certainly though, like if we have to reimburse the counties like we will at the end of every year, we're likely to make at least that one ask at the end of the year of IFC to say, you know, there might not be enough money here because we have to spend more money to reimburse Elko or White Pine County or whoever it might be, and please, you know, supplement that bucket of funding so we can get those reimbursements out to those counties.
And again, this kind of goes in, like you know from that Davis consent decree that there are certain requirements. We also, just yesterday, were talking about 80K, what is the indigent? Yeah, 80K, there we go, 411, see, I knew someone would know it. Again, are those some of the things that you took into consideration in determining how many employees or how many staff people you would need to be able to comply with some of those already existing requirements on addressing these cases and being in compliance with that federal order?
Peter Handy for the record. So when it came to the fiscal note that's proposed by the department, yes. So the alternate public defender, the way that I scheduled it was basically how many attorneys do we have in the NSPD that are set to fill the roles right now in White Pine County and as proposed in Humboldt County, and the need indicated under the workload that was adopted by the board. And so the additional attorneys are recommending at least there's 1 for White Pine County and 2 for Humboldt County. And those would be to take those conflict cases, and that would meet the workload requirements right now for both of those counties. Should we be able to fill all those positions and contracts?
Are we good, Senator Nguyen? Thank you. Members, any additional questions? Seeing none, thank you both again for the presentation. At this time, I'd like to invite those wishing to testify in support of Senate Bill 407, if you could please come forward, either in Carson City or Las Vegas. We have none in Las Vegas, but I do have some folk here in Carson. Good afternoon, welcome.
Good afternoon, Vice Chair, members of the committee. My name is John McCormick, J-O-H-N, last name McCormick, M-C-C-O-R-M-I-C-K, the Assistant Court Administrator at the Nevada Supreme Court, AOC. And I do happen to know that administrative docket number, 80KT411, as I was staff to that commission for its entirety from 2007 to 2021. And in that vein, the court continues to be concerned or supportive of improving our access to constitutionally adequate indigent defense services. And also, we think that this will help with a problem that we're looking at now currently, which we refer to as legal deserts, meaning that in addition to not only indigent defense services, in the entire state, and particularly our rural counties, we experience what we call a legal desert. There's less than 2 available attorneys to perform legal services for those residents per 1,000 people. So again, the court is supportive of making these efforts to improve not only the delivery of indigent defense services, the delivery of those post-conviction services, but also to continue to improve just access to legal services in the state. Thank you.
And we do have a question for you. Senator Hansen, please. Oh, Senator Ellison, and then we'll go to Senator Hansen.
Good seeing you again. Is there a pile of money that they always fund into this every 2 years? Is that how they do that, or do they have to have that out of the current budget of that year?
Thank you, John McCormick, for the record. The Supreme Court doesn't itself provide money for this. The function comes through the Department of Indigent Defense Services, where you just heard from Peter, and that's appropriated to that department every biennium by this legislature. And then also counties and cities have their own individual budgetary requirements to provide those counsel to indigent defendants.
Follow up, sir?
Please follow up.
And what happens if the budget's short? And at that point in time, we could have got hit with maybe a large bill with the college system, but if we'd have got hit with that, then there'd have been less money not available. So at that point in time, they just have what they got and then put that out. Is that how that works?
can't, again, John McCormick for the record, can't speak particularly to each individual situation. However, there is a constitutional requirement, as was referenced during the bill presentation under Gideon v. Wainwright, that a indigent person who's charged with a crime and faces loss of liberty under Argesinger versus Hamlin, I think, is required to have counsel provided for them, and so it's an obligation that doesn't go away regardless of the existing budgetary resources or lack thereof.
Okay, that's what I want to know. Thank you.
Senator Hansen, please.
Thanks, Mr. Vice Chair. The Office of Post-Conviction Counsel, I apologize, I didn't catch that in the beginning, because we have the alternate state public defenders, which is for rurals. I'm just curious, were you guys, will this fall under your jurisdiction when we create the Office of Post-Conviction Counsel? And if so, why is it needed in Washoe and Clark counties? You know, I'm trying to focus, see where the actual need is. I don't understand why in those two highly populous counties we got to have this special new branch created.
Thank you, John McCormick, for the record. The office would not obviously fall under our purview, as that would be a conflict, because the Supreme Court is the appellate court that may be hearing some of these post-conviction petitions for relief. And currently, the state pays for all those post-conviction attorneys when they're appointed. So this, I think the idea behind this bill is to put that into a state office to better manage that. And currently it's for the entire state. So there would be, I think, a benefit obviously to our larger counties in that, you know, the state would sort of take over that function more completely with this office and wouldn't be, you know, searching for those appointees, and obviously would benefit the rurals too. When we're talking about post-conviction relief, generally, as Mr. Handy indicated, that's where we're talking about, you know, after a conviction, say we have someone who's been convicted of murder, they contend that their attorney during the trial did not meet the standard for performances set forth in Strickland v. Washington. That's a United States Supreme Court case, and then our performance standards that the Board of Indigent Defense Services has adopted through DIDS. So that it's a real specialized area of practice for these attorneys, because it's that sort of after the fact additional proceedings where they're looking for relief. In the example I provided, like they say their attorney, excuse me, didn't provide sufficient assistance of counsel, so that's considered differently than, say, the guilt innocence phase. So it's a more specialized area of practice.
Okay, my apologies. Yeah, post-conviction, I thought maybe it had something to do with the court system, but obviously it would be a very big potential conflict. But I'll take it up with the bill sponsor later. I'm just kind of curious where this all fits in. My idea was this is ideally for rural areas that already have a hard time in the desert, as you described it. So I'm kind of just wondering why we need a Office of Post-Conviction Counsel in those bigger areas, but I'll take that up with the bill sponsor, the chair of the committee, at a future time. Thank you. Thank you, Mr. Vice Chair.
And I don't think we have any additional questions. I do appreciate you staying back, holding on here for a little bit longer for some questions. Anybody else wishing to testify in support of Senate Bill 407? Seeing none, BPS, can we ask any callers who wish to testify in support?
Thank you, Vice Chair. If you would like to testify in support of SB 407, please press star 9 to take your place in the queue. There are no callers wishing to testify in support at this time.
Thank you. At this time, I'd like to invite anybody wishing to testify in opposition to Senate Bill 407. Seeing none in Carson City or Las Vegas. BPS, do we have anybody wishing to testify in opposition over the phone?
Thank you. If you would like to testify in opposition to SB 407, please press star 9 to take your place in the queue. There are no callers wishing to testify in opposition at this time.
Thank you. Lastly, anybody wishing to testify in the neutral position for Senate Bill 407, if you could please come forward, Carson City or Las Vegas. Seeing none, BPS, anybody wishing to join us in the neutral position over the phone?
If you would like to provide neutral testimony for SB 407, please press star 9 to take your place in the queue. There are no callers wishing to provide neutral testimony at this time.
Madam Chair, any closing remarks?
Thank you so much. There's just one thing I wanted to try to explain that might kind of help put into context the reason that we need this even in the larger counties. If you think about like a place like Clark County where the district attorney's office prosecutes all of the cases and the public defender's office handles, let's say, 60% of the cases, including, 50% of all cases that go to trial. At those trials, once a client of the public defender is convicted and they are sentenced to prison and they go up to High Desert or Indian Springs or wherever they are, essentially the entire public defender's office becomes conflicted off of that case because it really wouldn't be fair or make sense to have one public defender try the case in front of a jury and lose, and then have that public defender's, next door office neighbor come in and argue, oh, well, the public defender on the case was ineffective. She didn't do her due diligence. My client wouldn't have been convicted but for her poor performance. So you have to get them another attorney at that point. And so when you have that kind of volume, and then you can't just have one office that does all of the post-conviction. And so that's why every jurisdiction relies on individual appointed attorneys to do that post-conviction work. And right now it's kind of pieced together in this patchwork of experienced private attorneys, sometimes even people who generally do civil litigation but have experience in appeals who will take these cases on a one-off. And then there are actually attorneys who make most of their living by doing this, by taking these appointed post-conviction cases because they are so complex. Because after that dedicated public defender has slogged through 3 weeks of trial just for their client to get convicted, now it's someone else's job for the next 5 years to litigate all of the post-conviction. My attorney wasn't qualified. This evidence wasn't produced. The jury instructions were wrong. The jury panel wasn't diverse enough. All of the issues that can be raised after conviction's already been entered. Some people specialize in that. And so the idea here to create an office that is composed of a certain number of attorneys, 6, 8, 10 attorneys who can then be assigned to cases that they're not conflicted off of, I think actually does make a lot of sense. And so that's what I wanted to just kind of mention at the end here.
And I don't think we have any last questions here from the committee. Thank you for your closing remarks, Madam Chair. At this time, we'll go ahead and close out the hearing on Senate Bill 407.
Thank you so much. And that brings us to public comment this afternoon. Anybody wishing to give public comment here in person in Carson City or in Las Vegas is invited to the front now, but I don't see anybody coming forward. So we will go to the phones, please, for public comment.
Thank you, Chair. If you would like to provide public comment today, please press star 9 to take your place in the queue. There are no callers wishing to provide public comment at this time.
All right, then that brings us to the conclusion of our meeting. Tomorrow we are revising our agenda. I'm not sure if it's been published yet, but we are meeting at 1 o'clock as usual. We will be having a work session tomorrow, so look forward to that. It will be at the same time, same place. Until then, we are adjourned.